We can start already, or we will wait for some minutes?
Whatever you prefer. I'm okay with both options.
Carolina, what do you want?
You choose.
Maybe 1 or 2 minutes, and then we can start. I see people are still getting in and so on.
Yeah.
So welcome everyone. We're just waiting 1 more minute until everybody gets in the Zoom call, and then we will start the webinar. So welcome to everybody. Thank you for those who are also turning on their cameras. It's good to see you. Thank you, Caio and José, Rodrigo, Marco. So we have a lot of very interesting audience, Nicola. So get excited here already. Rodrigo, Marco. So Julia, I think if you want, we can start.
Okay. Are you listening well?
Yes.
Are you listening well, Franco?
Yes, we are.
Okay. Good afternoon to everyone joining us from Brazil, and good evening to those tuning from Portugal and the other time zones. Welcome to the webinar, Negotiation in the Age of AI, What Law School Didn't Teach You. This event is a joint initiative of the Católica Faculty of Law, Porto School, and ICFML, serving as your first step into our International Negotiation and Mediation Summer Program 2026. We are living through a profound transition. While artificial intelligence redefines technical, legal, productive, our ability to negotiate, mediate, and manage complex human interactions has become through competitive differentiation in the global market. Today, we are here to explore exactly what law schools traditionally haven't taught, but what the modern world now demands. To lead the discussion, I have the honor of introduce our keynote speaker, Nicolas Vermees. Professor Vermees holds both an LLD and LLM from the Université de Montréal and is a SISSP certified information security professional. He is a director of the Center for Research in Public Law, CRDP, associate director of the Cyber Justice Laboratory, and a professor at the Faculty of Law of the Université de Montréal. Additionally, he serves as a visiting professor at prestigious institutions such as William and Mary in the USA and the University of Fortaleza in Brazil. A member of the Quebec Bar, he has authored numerous fundamental works on the impact of information technology on law, focusing on civil liability and information security. Moderating today's sessions, we are joined by Franco Gevaert. Franco is attorney at Javaed Associados with a dual professional qualification in Brazil and Nova York. He has extensive practical experience as a mediator in both cultures. He is adjunct professor in the International Law Graduate Program at the Pontificio Católica University of Paraná and holds a Master of Laws LLM in International Commercial Law and Dispute Resolution from the Strauss Institute at Pepperdine University. Furthermore, he serves as a coordinator of the CPR Brazil Mediation and ADR Guide and is a widely published author in the field of alternative dispute resolution. Without further ado, to kick things off and lead today's discussion, I will hand the floor over to moderator Franco Gervaert. Franco, the floor is yours.
Thank you very much, Victoria. Thank you also to ICFML and Católica Faculty of Law for organizing this event, which we have the honor to have Professor Nicolas Vermeil with us. So I know we have a very qualified audience, so I welcome also those of you who are here with us. And I think they are curious, Professor, to know about what you have to teach us today, as I am also. So I will start with the first question already, which is we are going to discuss today how AI, artificial intelligence, is affecting the legal profession. So I think it would be useful to have a quick definition of what do you understand as artificial intelligence. Please, Professor.
Thank you, and again, thank you for inviting me to speak with you today, and it's a great pleasure and a great honor. But as Franco mentioned, we're gonna try to be formal, but it's gonna fail miserably because we've spoken a few times already, and he's such a nice gentleman that I'm gonna have difficulty saying professor. So apologies for being so informal, and I invite you to be as well. But obviously, if we're going to talk about how artificial intelligence is impacting us, it's important to have a common understanding of the term. And the main issue that we see when we're dealing with artificial intelligence and its impact on the legal system is that no two individuals will actually use the same definition. I was actually reading an article this morning that said that they had a list of at least 200 different definitions of artificial intelligence. And obviously, depending on the definition you use, it's going to have an impact on everything else, including how it is affecting, in our case, dispute resolution. So I always like to go back to the origin of the word, or the expression, I should say. So many of you may know this, but for the others, so artificial intelligence is an expression that was actually invented in 1955, used for the first time in 1955 by John McCarthy and his colleagues when they were presenting a grant application for a summer program that they were leading on the use of artificial intelligence. And it's actually funny because at the time they were asking for, I believe, $3,000 US in 1955. So that's roughly $150,000 US in today's money to, and I quote, settle once and for all the artificial intelligence question. Now, they were obviously off by a few years and a few dollars as well. But their definition was basically artificial intelligence is when a machine behaves in a way that would be considered intelligent were a human being to behave in the same manner. Now, that's a very inclusive definition, but it's also a very problematic definition because it's so wide that really it doesn't help you much. Because according to that definition, a calculator would be considered artificial intelligence because if your child, for those of you who have young children, if your child goes up to you and says, Mom or Dad, 5 plus 5 equals 10, if you're a good parent, your reaction is going to be, congratulations, you're really smart, you're really intelligent. Well, you've just then established that a calculator that does the exact same thing is intelligent. So I don't know how useful that definition actually is and how well it aged. So I always like to go back to the OECD definition that was adopted in 2019 and tweaked over the last 7 years. Why? Because it's the one, as many of you know, that has guided other definitions. So the AI Act in Europe is using that same definition. In the US, that's the definition they use. In Brazil, the projected legislation uses that definition as well, same as the one we have here in Quebec. All that to say, it's the most commonly referred to definition in the legal system, and that is that an AI system will do at least one of four things: generate predictions, generate content, generate recommendations, and generate decisions. And the reason why that's so interesting for us as lawyers is that those are actually the four things that we as legal professionals do. Right? We try to predict the outcome of a situation, to suggest a path to our client, or if we're acting as a mediator, to both parties. We generate content, i.e. write procedures, write contracts, it could be a transaction to help settle a mediation, recommend to our clients to settle or not to settle, or recommend to the parties how to move forward, and eventually, if we're acting as an arbitrator or as a judge, make a decision. So that's actually, AI is doing the four main components of what legal professionals do. And that's why I think this definition is particularly useful, and why I always stay attached to these four functions of artificial intelligence rather than look at the technology behind it, whether it be machine learning or deep learning or whatnot.
Professor, taking in consideration this last definition that you mentioned, how do you see that AI is currently being used in the context of the legal profession, especially dispute resolution?
Yeah. So again, coming back to those four words, those four functions, prediction, well, there are a lot of predictive tools that are out there. For example, in the US, there's a tool called Premonition that you can actually ask the tool which lawyer you should hire depending on which judge you're going to appear in front of, to see which lawyer has the best win-loss record in front of a judge. I personally find that a little laughable, because it's not like there are no other factors than the lawyer skills to decide whether or not they're going to win. But and obviously there are a lot of other tools now that are available that will predict outcomes. And in fact, there are some even that are helping judges. Some of you probably heard of the Compass case in the US that has made a lot of win around the world, which is a tool that is being used by judges to predict the recidivism rate of accused of people that would be accused of a crime, and that will help them decide, well, how many years to impose as a prison sentence, for example. Again, these tools are coming under attack, but they do exist. Generate content, obviously, these tools are being used by self-represented litigants, by mediators, by lawyers, by judges to help them draft documents. Recommendations, again, same as the predictions, people will ask the AI, and this is particularly true of large language model based tools that are available for either lawyers or self-represented litigants, or in the mediation context, even the mediators, to suggest how they should proceed, what arguments to put forward, and so on and so forth. And finally, decision, and that is something that is a little outside the scope of mediation, but the idea of eventually having AI decide in certain cases. And in fact, it is something that already exists. Now I'm drawing a blank. The privacy GDPR. There you go. I had it in French. So GDPR actually has a section that states that decisions can be made by artificial intelligence, but if that's the case, there has to be some sort of an appeal mechanism. And so these are just examples. Again, these tools are being used by parties to help draft documents, to simulate a mediation process, to try to help you bolster your arguments and see how you're going to proceed, and so on and so forth.
Thank you for your answer, Professor. That predict possible outcomes, generate contact, helping to draft, even making decision if there is an appeal mechanism afterwards. So most people maybe think about the positive, possible, potential positive aspects of it, right? Like less work basically for us humans. But I'm sure there are a lot of concerns, and I also want to invite at this moment the audience, as we have very qualified people here with us, and also students that are probably interested in the summer program in Porto, which we highly recommend not only for the education content, but also for knowing the city, which was being discussed with Danielle before the session, right, Danielle? About how is one of our favorite cities in the world, including you, Professor Nicola, right?
Absolutely.
So we also invite you to get to learn more about the summer program and to make questions here, because this is actually an introductory session to the summer program. So we encourage your participation and to make questions to the professor. But as I was saying, we think mostly of the positive aspects. But Professor, I'm sure, and also we are getting to learn now some of the risks associated to the use of these tools and artificial intelligence. So I wanted to hear from you and also from your experience in Canada and in the world about those risks, please.
Yeah, so obviously the biggest risk, or at the most, I would say, commonly referred to risk is that of what is referred to as hallucinations. And I'm sure it's something that most of you are very familiar with, the idea that, especially when we're talking about generative AI models, so the ChatGPTs of this world, will generate content that is very often just flat out wrong. Now, I personally hate the expression hallucination. I think it's too cute for what it actually is. Some have suggested to use confabulation, which is a mental construct that basically forces you to generate fake information. And I do apologize because I'm going to be very rude for a few seconds. There's an American author called Harry Frankfurt who developed almost 40 years ago now, a theory that he called the theory of bullshit. And the idea being that there's a distinction between a lie and bullshit. Most of us that are professors are familiar with the idea of bullshit, right? A liar, we know what it is. Somebody that says something which they know to be false. Someone who bullshits doesn't know what they're saying is false. In fact, they hope that it's true. Right? If a student doesn't know the answer to the exam, they're going to write anything down hoping to get a few points. Well, that's bullshit. And that's exactly what these large language models do, right? It's a predictive model based on statistical analysis on what is the most statistically probable term to follow the one that was there before. And so it will generate content, doesn't really care if it's true or false. It just wants to give you information that you'll be happy with. And so this is something that has become a huge issue in the legal profession. There's a website that's maintained by a French jurist called Damien Charlotin, which some of you might have heard of, that basically chronicles all the cases around the world where lawyers or self-represented litigants or mediators or arbitrators or judges have used generative AI mostly to help them draft documents or even draft decisions in certain cases, and have fallen short because of the bullshit that is generated by the tool. And just give you one example out of Quebec. So this morning, a colleague referred to me a decision that came out 2 days ago, where an arbitrator rendered a decision and the parties appealed to the court saying, well, that decision was clearly written by artificial intelligence. And I just want to read you very quickly two paragraphs from the court's decision. They say the preponderance of the evidence therefore leads to the conclusion that the arbitrator's authority was delegated to the artificial intelligence, and that he abdicated his role of reviewing the outcome. This conclusion, which is striking down the decision from the arbitrator, is inevitable given that all the doctrinal and case law references on which the arbitrator relies are non-existent or imaginary. And unfortunately, this is just the latest example from here in Quebec. Last I checked in Quebec, or in Canada, we have close to 40 cases now where individuals were taken. Around the world, we're now there's over 1,000 cases that were found that basically lawyers, or again, judges or mediators or so on, have been using these tools. And what's particularly discouraging, or I wouldn't go as far as saying frightening, but particularly problematic at least, is that I've noticed that a large majority of the cases are self-represented litigants, or individuals that don't have the luxury of having legal representation because they can't afford legal representation in many cases, that are turning to these tools. There's even a case in Quebec where the self-represented litigant said, I knew when I filed my motion drafted by AI that I was running a huge risk that it was going to generate false content. But I don't have any other option because I wouldn't know where to go, what to do, what to write if I was left to my own devices, and I can't afford a lawyer. And so that, to me, is one of the main issues and thing that we have to keep into account. And this is particularly true when you're talking about negotiation or specifically mediation. Why? Because, as I mentioned, these tools are built on statistical models, using a lot of data, accessing a lot of information. Well, training these tools on case law from a common law jurisdiction is one thing, but mediation in most civil law jurisdictions, mediation is considered private. So the data is not available to train an algorithm. So these tools are not well trained to help you take part in a mediation process because they don't have access to the data. And so the risk then becomes all the more important that they're just going to make up anything to help you, and it might cause more harm than good.
So what I hear, Professor, is that as a good mediator does, we need to be careful with our assumptions, right? So the assumption that only good comes with the AI is not accurate, because you need to double check. It can be helpful as a tool, but it doesn't substitute your knowledge, your work, or even, I mean, as you said, the most cases are because people didn't hire or weren't able to hire or have assistance of a legal profession. So we need to be very careful, right?
Exactly.
Thank you for this. This is very clarifying, because I'm sure in Canada we have more cases and more development of this, comparing to Brazil, where still, we were learning a bit of those things.
Well, I don't know necessarily that it's because let's face it, you have a lot more court cases than we do since you have a bigger population. I think the advantage we have in Canada is just that our case law, because it's a common law jurisdiction in most provinces, obviously Quebec is the exception. We just have more data on all of this. In fact, when you look at the jurisdictions that have the most cases that were found of people that used AI and didn't check their references, it's jurisdictions that have basically, again, common law jurisdictions where there's a lot of cases and where the search engines to go through the case law are particularly efficient, ironically, because they themselves are using AI algorithms that allow to find those cases.
Professor, going forward, there are a lot of dispute resolution platforms claiming to incorporate AI on those platforms. So what's your vision about that? Is this really the case, and how these AI tools are being integrated into these platforms?
Well, that comes back to the first question, right? What is artificial intelligence? So I'll give you one example that I think is particularly interesting. So in 2019, there was an article in a lot of British newspapers saying a robot mediator settled the case in 3 hours when the courts had been working on it for 3 months or something to that effect. Basically, a robot mediator managed to settle an issue between the parties where the courts have failed. And then when you read the article, they were saying, yes, this is a platform, a revolutionary platform that uses artificial intelligence to help the parties settle the dispute. So obviously, as somebody who works in that field, I was somewhat curious. So I read the article and tried to figure out what the platform in question was. And to my surprise, this robot mediator is actually a platform that I'm very familiar with because it was developed by a Canadian colleague of mine who lives in British Columbia, so at the complete other end of the country. In fact, it's probably as fast for me to go to Brazil than it is to go to British Columbia. I exaggerate a tad, but he's launched Ernie is his name, and Ernest, and he launched this platform in 1997 called SmartSettle. And SmartSettle is a blind bidding tool. So the idea being that instead of you and I negotiating directly and me saying, well, I want $1 million and you countering with $100 or 100 euros versus 1,000 euros or whatnot. Well, obviously, if we start that far apart, it may discourage us from going forward because we'll say, well, we're just too far apart. Let's just stop negotiating now. This tool uses blind bidding. So instead of one of us telling the other one what we want, we simply tell the AI, I want €1 million. And you will answer the AI saying, I'm willing to give 1,000 euros. And then the AI will just come back to both of us and say, you're not near one another, make a second offer. And so on and so forth until we reach the same number or fall within a pre-established distance one from the other. Now, that's a very useful tool when you're dealing with monetary values, and it's a great platform. I have nothing against the platform. But when you're talking about a robot, a mediator, that's not exactly what people are expecting, right? People are expecting an avatar that will interact with both parties like a mediator would do in real life. So while this is a great technology, saying a robot mediator settled the issue. And again, this is technology from 1997. Obviously, he updated the code, but this isn't particularly new. So in fact, just to finish that anecdote, so I was at a conference a couple of months after that article, and I saw the president of SmartSettle. So I went to say hi, and I said, oh, by the way, congratulations. I said, I didn't realize that you had added AI to your platform. He says, I haven't. It's just that everybody's using the expression AI now, so I decided to use it as well, which is very smart on his part. He says, but the AI I use is the exact same AI I used in 97. It's just nobody called it AI back then because it wasn't the buzzword that people were using. So you have to be careful depending on, people say we use AI, but what is it really? Are they using large language models? Are they using machine learning algorithms? Or are they using good old-fashioned AI, i.e., symbolic AI, which is knowledge trees and things like that, which are, again, probably the best sort of AI because it's the most reliable, but it's not what people in the media are talking about. So once you know that, well, there are obviously other platforms out there that are using more modern forms of AI, that are using machine learning algorithms to find information. And it's also mostly it's mostly tools that will help people navigate through a dispute by giving them information, answering questions, basically chatbots, right? That will be on these platforms. Now, there are some that are starting to offer AI mediation services where basically the AI is acting as the mediator. But even those, when you actually scratch underneath the surface, you realize that it's not as sophisticated as one might think. And I would argue that that's probably a very good thing, at least for now.
While you were talking, Professor, I remember you referred to some chatbots and so on. So I remember the eBay platform, which was pioneering the ODR, online dispute resolution, So do you think there is going to be, or is there already a marriage between AI and online dispute resolution? And also, I'm going to send two questions already.
Oh, well.
Too curious, but just to take advantage of what you said about AI possibly, not possibly, but the possibility or the idea of having an AI mediator or something like this, like a robot mediator. Do you think this is viable, or is this a possibility, Professor, in your view?
So I'll start with the first question, just to keep people online until the end. So with the first question, first of all, maybe just for those of you who are online who are not necessarily familiar with online dispute resolution. So online dispute resolution is a series of mechanisms used to basically facilitate dispute resolution using technology. Now, the classic model of online dispute resolution is a three-prong approach where you start with both parties using a platform to negotiate. If that fails, then a third party, a mediator, will join the platform and try to help them settle the issue through mediation practices. And if that fails, then the mediator will be replaced by, in most cases, in the classic model, an arbitrator. What we're seeing more and more in Canada, for example, is by a judge, where this is just a platform that is now used by courts. And the arbitrator or the judge will render a decision. Now, again, there are different mechanisms being used by these platforms. I talked about blind bidding. Some of these platforms will use video conferencing. Some of them will use text exchanges. Some of them will use forms. So there are different mechanisms, but the idea is you go through these three prongs, these three steps. And over the last few years, what we've seen is, again, these platforms incorporating artificial intelligence. And again, depending on how you define it, but specifically in the last 4 or 5 years, generative AI tools into their approaches. And there are two schools of thought about this. The first one is what is referred to as AIDR, so artificial intelligence dispute resolution. And that's the principle that we were referring to a few seconds ago, the idea that someday we could replace the third party being the judge, the mediator, the arbitrator. So the person that is either hired to help facilitate negotiations or to just settle the dispute altogether. So replace that individual by artificial intelligence. And there were first pilots. Actually, the first pilot that I saw of this was an application on the Amazon AI there, Alexa, where you could actually download an app called the Kids Court, where you could just sit your children in front of Alexa and she would transform into Justice Alexis. And then Justice Alexis would hear the dispute between your children. She pulled my hair. Well, she started it because she stole my cupcake. And you can imagine the children's dispute. And then after hearing all of this, Justice Alexis would say, okay, well, I heard everything, and this is what is going to happen. You have to stand on your head for 10 seconds as your punishment for pulling your sister's hair. So that was one of the first incarnations. Obviously, this was done more in an educative and gaming type of way, but it already gave us an idea what the technology can do. Fast forward to today, there are companies now that offer avatar-mediated services. So there's a company out of the US called Bot Mediation, where you can actually have an avatar, an AI persona that is basically acting as the mediator between parties. There's a place also here in Montreal called themediator.ai that they don't use avatars. They're doing it more as a text-based service, but they still, basically the AI is still the one mediating the dispute. We here at the Cyber Justice Laboratory, we developed a tool called the LL Mediator. And this tool originally fell more in the second category. So I talked about AIDR. That was the first category. The second category is what we chose to to name ODRE. ODRE for ODR AI. So ODR, aided by augmented intelligence. And we make a distinction between artificial intelligence and augmented intelligence. Augmented intelligence is a terminology that I personally first heard from Luc Julia, who's the gentleman that developed Siri for the iPhone. And he says, well, we should never have used the term artificial intelligence. Again, this was something that was used for a grant application in 1955. It caught on, but that was not necessarily the goal. And talk about augmented intelligence, because that's what these tools are supposed to do. They're supposed to augment human intelligence. And so we developed a tool called the LL Mediator that basically is there to give information to individuals during the negotiation mediation process. And so, for example, during the negotiation process, parties can ask it, well, what do you think I should do? Or what, and also if Franco and myself are negotiating because, for example, I am a merchant and I sold him a defective product, well, he might be very mad at me when he enters the negotiation process and say, well, you're a crook, you're not a very good businessman, and so on and so forth. And then the LL mediator will actually stop him and say, before I send that, are you sure that's what you want to say? Don't you think it would be more productive to say, I am not satisfied with the service I received, or the goods I received were not what I expected? To start on a more neutral tone. And when the mediator joins, as I mentioned, it was negotiation, mediation, and possibly a third step. So when the mediator joins, if the parties haven't agreed on anything, then he can use the platform to, he can ask the AI to help summarize, for example, the exchanges that have happened up till now to get an outlook. He can even ask the AI to do an analysis of the vocabulary that was used by the parties to say, they're pretty aggressive right now because they've used words like liar and thief and criminal and so on. And so it helps him get a better picture of the arguments that were already presented, how he should handle things moving forward. Now, because we're researchers, we decided to push things further and say, well, can we actually get this LL mediator, which originally was an ODRE approach, and bring it into the AIDR field? Basically have the tool mediate instead of actual individuals. And so we actually created mock mediations and submitted it to the LL mediator and submitted it to people that were mediating these cases, and then evaluated the satisfaction rate of the satisfaction that people had, that the parties had with one or the other approach. And people were actually more satisfied with the AI than they were with human mediators. Now, a couple of elements that I need to specify here. The first one is these were relatively simple cases. So obviously this does not mean that these same tools could be used in more sophisticated cases. Second is these were law students. These were not certified mediators. So obviously they did not have the same skill sets as professional mediators do, and that probably had an impact. So I'm not saying that RL mediator is better than mediators. I'm saying that it did raise questions, and in certain cases, for these particular types of mediation sessions, it seemed to be relatively positive as an experience. And this actually brings me to your second question, which is, well, are we ready for mediators, for AI to replace mediators? And I'm not sure that's the right question. I think the question is, where can these tools be helpful? The idea of replacing mediators completely and basically this being a profession that no longer exists in 5, 10, 15, 20 years, I think that's ludicrous. I think even if the technology was able to replace all mediators, I don't think that we as human beings are ready to have certain types of cases mediated by a machine. I think we still need the human interaction, the human contact, and so on. But I also think that there are areas where we can't really afford a mediator, or we can't find a mediator. And so it's not a question of should AI replace mediators? It's when no mediator is available because they are physically or financially unattainable, is it better to have an AI do the work than nobody and stay in a conflict situation that is not resolved? And I think the answer to that obviously is you're better off using AI. Now, that doesn't mean using any type of AI in any condition. That's why we're doing these pilot projects. That's why we're testing things. I don't know what these companies that I mentioned, the mediator or bot mediation, I don't know what they did as tests. Hopefully, they were responsible and tested their software to make sure that there were no issues with it. But I think there is, for certain cases, what is often referred to in American doctrine as high volume, low value cases, which is an expression I don't particularly like because how dare we say that something is low value? Because what's not valuable for you and I might be extremely valuable for another person. So I like to talk about low intensity from a legal perspective, right? They're not constitutional cases. These are basically simple from a legal perspective issues. From a factual perspective, they might be complicated, but from a legal perspective, they're not. And so for these types of cases, I think there is definitely a possibility for these tools to be developed and made available, again, for the people that can't afford to have mediators or lawyers.
Well, I think that the result of that research, that although they are students that were acting as mediator and participating in these mock mediations, that they were more satisfied with the AI mediator. I'm sure that triggered some questions here to our audience as well. So we still have about 20 minutes of the lecture, and I want to re-encourage our audience to make some questions. So I see Maria Inês Campos has her virtual hand raised, right? So Maria, please.
I think she left the frame. Oh, there she is.
I'm not sure whether you have a question.
So sorry. I didn't intend to up my hand. I don't know what happened here. It happened already yesterday. I'm so sorry. I'm thinking it's so great, but the hand updated by itself.
I think that might be an hallucination of the system here of the.
There you go.
Because there is this conspiracy theory, and I don't know until what point is this conspiracy theory where, I mean, like the science fiction movies that robots may act by themselves, but I know this is still like being researched, right, Professor? I don't know whether we should dwell into this or not, but
well, there are actually documented cases. I think it was Anthropic that their AI at a certain point, basically they fed it. Now I want to make sure because there are three cases and I never know which AI it is. But in one case, they fed the AI fake information about the fact that the president of the company was having an affair, and then when they tried to tell the AI that they were shutting it down, it said, "You're not going to shut me down because if you do, I'm going to mail information about your affair to your wife." And there were other cases similar where they were trying to update an AI and said, "No, I don't want to be updated or I don't want to be changed." And so there is already that issue with certain platforms, especially large language models.
And I think this was one of the reasons also that they were like the new version of the Anthropic is still on hold or something like this. There are some discussions with the US government. I see some news about that. So there are still some concerns about the developments of AI. But I don't want to go to other, it's AI related, but let's see what Alessandra, thank you for being here with us. I think you might have a comment or question, right?
Yes, I do. Can you hear me well?
Absolutely.
Great, great. Well, thank you, Franco. Thank you, Nicolas, Professor Vermais. I'm based in São Paulo, in Lisbon, and here in Lisbon, I also teach at Católica's negotiation skills. And I'm very much interested in hearing your thoughts, Professor, regarding ethics. We so much discuss ethics on negotiation, and we discuss the issues of ethics when using artificial intelligence. I would love to hear your thoughts on the overlaps of, ethics when we're using artificial intelligence in negotiations. How do you see the new challenges we have in combining different fields with their own ethical issues?
That's an excellent question, and so thank you. Oddly enough, well, not oddly enough, but Quebec lawyers, we are the only lawyers in North America that our code of ethics actually stipulates that we have to be computer literate. It's implied in all other codes of ethics, but we're the only ones that actually it's explicitly mentioned. And in fact, there's actually a mandatory AI ethics training for all lawyers in Quebec. It's a training, a 3-hour online training course that I actually did a couple of days ago. And obviously, the main takeaway, which is what I already knew, but this confirms it, is transparency. And what's interesting is you were saying, well, there's ethics in AI and ethics for mediators, and both will use transparency. But transparency doesn't mean the same thing in both cases, right? The term isn't used in the same way. Transparency in AI is so that you know or you understand where the AI is getting its information and how it's working. Transparency on our side is to basically be clear as to what to expect. But I think they can marry very well. I think one of the ethical obligations we have definitely is to tell people if we're using AI, how we're using the AI, and when we're using the AI. And the other thing, and it's probably one of the main takeaways that I want you to have from this presentation, I'm not for or against AI. I think AI has some wonderful sides to it, and I think it's one of those things. It's the most dangerous weapon in the wrong hands, and it's the most beautiful tool in the right hands. It's just a question of knowing how to use it. And the first question you have to ask yourself is, do I know how to use this? Will I be able to use it in a way that will actually help my clients in this mediation? Or am I risking things from a privacy perspective, right? Am I going to put data into the system that might impact privacy laws and the rights of these individuals? Intellectual property, possibly, right? If they're discussing the property of certain items that they've created, for example, a mediation between two co-authors, and well, if you put the work that they've created into an AI, we know, according to the rules, the terms of use of these tools, very often they'll use anything you feed them to train the algorithm. So now you've basically violated their copyright, and so on and so forth. So you have to understand and know how to use the technology, and the approach, or in AI jargon, there's an expression called the sandwich approach. And the sandwich approach is, right, you have a sandwich, you have a slice of bread, and you have your meat, and then you have another slice of bread. Well, replace bread by person and meat by AI. The idea is you have a person that will tell the AI what to do. Then the AI will do its thing and it will produce an outcome. And then you have to have the person. It doesn't necessarily have to be the same person, but there has to be another person there that will look over what the AI did and ensure that what it's done is useful for your client and it's not going to cause more harm than good. And that's the element that all of these cases that I was mentioning before of individuals that were just using AI and that the courts have penalized in one way or another. That's the stage that they forgot. And that's the stage that we as legal experts and you as mediation experts, that's what we have to remember is our main qualifications. Yes, AI can do a lot of what we do, but we have the expertise to validate or invalidate, in many cases, what AI does. And my fear when we're talking about ethics and the use of AI is not for our generation or even for Franco's generation, because unfortunately for me, Franco is much younger than I am. But it's for the younger generations that are starting out. If they rely too much on AI, they won't acquire the skills that we've acquired, the knowledge that we've acquired. And so they won't be qualified to act as the second slice of bread and try to and correct and see what the AI does. And just to give you an example of that, it has nothing to do with this type of artificial intelligence, but every time I'm still attached to paper money. I still pay with paper money and coins whenever I can. Um, and whenever I'm at the cash and it's a teenager that's behind the cash, and if they say it's 8.75 and I give them $10 or 10 euros, and then they look at the bill and then they look at me and they're very confused. And I'll go, you have to give me back a dollar or euro 25. And you can see that unless they have a calculator, and sometimes they'll take out their phone and actually do the calculation. So unless the cash register does the calculation for them, they're completely lost because they haven't learned to add and subtract in school because they have easy access to a calculator, which we didn't have when I was a child. I mean, we had calculators, we just weren't allowed to use them in class, and now clearly they are, so they lost that skill set. And that's what I think as legal professionals, and we were talking at the very beginning, right? What they don't teach you in law school. Well, what they don't teach you in law school is if you rely on AI right now, in 20 years, you'll be totally useless. Whereas if you learn the skill sets right now, in 20 years, you're still going to be around to tell the AI what to do. And that's something that is extremely important for the younger generations to realize.
Thank you. Thank you for your thoughts.
Thank you. Also, Professor Alessandra, nice to meet you as well. So
Likewise.
we still have a few minutes. So if anybody in the audience wants to make another question, I think we are heading to the end of this lecture. A very rich lecture, by the way. Thank you, Professor Nicolas.
You're very welcome.
You mentioned that, I mean, it's clear, I mean, I think to everyone already that AI is having an impact on legal profession, even if you are lawyer, mediator, arbitrator, negotiator, even to the whole society, right? So
absolutely.
My last question, and I also want everybody to have at least one more question. If you want, please send in the chat bot here in the chat. Or you can also ask to AI to make a question maybe, Professor Nicola. I don't know. But
I'm open to it.
Yeah. My question is, what should legal professionals, attorneys, mediators, and students do now to prepare themselves for this impact? You already mentioned for them to study in the law school and not forget to study the actual techniques and so on. But I'm wondering whether there are any other advices.
Probably, and this is an example I like to use, a historical comparison. Don't be farriers, be blacksmiths. Now, for the younger people here, farriers are the people that make horseshoes or the people that made horseshoes. I mean, there are still some farriers today, but there are not that many. And what happened to farriers? Why are there not that many today? Well, it's very simple, because when automobiles started arriving, there was less of a need for horses and therefore less of a need for farriers. And so a lot of farriers just couldn't find any work anymore and they lost their jobs and the profession more or less died down. But then there are those farriers that remembered that they were blacksmiths. It's just that they were blacksmiths who were specialized in making one particular thing out of metal, and that is horseshoes. But that skill set was transferable. They could make parts for automobiles as well. And so they could actually get more jobs, more money, more business by simply changing their approach, than sticking to the approach that they had. So where does that bring us? Well, to what we were discussing before. The days of lawyers doing all the work on their own are probably behind us. A lot of people will say, well, this is the end of lawyers, this is the end of law, this is the end of mediators, AI is going to replace us. AI isn't going to replace any of us if we're smart. If we're smart and we become blacksmiths rather than farriers, if we actually understand where these tools can be helpful, because there are things that undeniably these tools do better than we do. I was talking to a former colleague who retired a few years ago, and he was explaining to me that when he started working at his law firm, he would have to spend hours and hours and hours going through boxes of documents just to put the documents in chronological order so that they can start doing the work. And then the documents became technological. And then there's just a one button to press in your window to just put the documents in chronological order. So what would take him all night to do, with a computer you can do in half a second. So there are ways that the AI can help you and make your job a lot easier and make you a more efficient mediator or lawyer. Getting back to the ethical question of Professor Murao, that also from an ethical standpoint means you have to adapt your fees in consequence. You can't keep on charging 6 hours of work for pressing on one button to put things in order, to stay with that example. But there are also other things that the AI will never be able to do. And one thing that I've noticed, because obviously working in this field, I work a lot with legal professionals, but I also work a lot with IT specialists. And here at the University of Montreal, we have the privilege of having Yoshua Bengio here, who is one of the foremost experts in the world on artificial intelligence, one of the fathers of deep learning, which is the technology that is being used in other things, among other things, to program large language models. And at a certain point, we were both were panelists on the same panel for a conference. And he started explaining why the AI could replace lawyers. And as I was listening to him, I realized he has no idea what we do for a living. Technologists don't necessarily understand the intricacies of what a mediator does, of what a litigator does. They see what's on television. They see what's in the movies, but from a day-to-day, the humanity that we have to bring to our profession is something that is probably as important, if not more important, than our legal knowledge. But that obviously is not something that is in the law books, and you can't train an algorithm on that. And so it's developing these people skills, understanding what the law does, understanding how the algorithms work and what their information they're going to spend, so that, again, you are the blacksmiths who know how to use this technology to make more money and become a more complete and more complete lawyer or mediator and contribute to society more and let's be honest, profit from it more as well. Or do you want to stay a farrier, keep on doing what you've been doing for the last 20 years? And if you're 5 years or 10 years from retirement, great. But if you're just starting off and you want to be a farrier, I have bad news for you. There's probably room for 2 or 3 of those per country, if that's about it.
Professor, just to wrap up, one takeaway from all the things we discussed, like if there's only one thing to remember, and we are going to remember all of them, of course, because it was a great lecture. But if you're going to choose only one, which do you hope that thing would be?
I stick with the sandwich method. I think it's the most visual cue, and I think that's what's easier to remember, and I think that's what's going to serve you best. The sandwich method: a human being has to tell the AI what to do, and then a human being has to validate what the AI has done. And as long as that's the approach that you're using, you should be good. But if you fail to have those two human interactions, then you're letting the AI do what it wants. And then we're drafting into science fiction territory with the Terminator and all of those scary machines scary futures where we don't want to go.
Thank you very much, Professor. I will thank you very much again for all the interesting content you bring to us. It was very clarifying. I'm going to hand on the word now to Carolina, which is going to make a final announcement. So thank you, everybody, for the participation, and thank you specifically Professor Vermes, Nicolas Vermes, for the lecture. Carolina, please.
Thank you, Franco. Thank you, Nicolas. Thank you, everybody. Can you see my screen?
Yes.
Okay. So now I'd like to invite everyone who joined this webinar to join our sermon program. What you saw today is just a small part of you can experience in this program. So here's now our agenda and our classes that you can attend either online or in person. And here you have the chance to learn from incredible professors, including Nicolas, that's here. And this is our 2026 agenda. And wait a minute, please. Okay. And it's not just about this classroom. Beyond the academic experience, both theory and practical, we also offer an amazing social and culture program. And now my colleague Isabella will tell you more about it. Isabella, you can go.
Hi, thank you, Carolina. First of all, thank you, Professor Nicolas and Franco, for the discussion today. It was really, really interesting, given how current the topic is. Even in my law firm, we're always discussing on the ethical use of AI. We're deploying and using different AI platforms like Oda and Harvey. So I'll definitely leave here with some food for thought to share with my colleagues tomorrow. And it's also very nice to see a lot of familiar faces and also new faces that I hope to see again in July. I'm Isabella, as Carolina said. I am a master's student at Católica University in Lisbon, and I am also a trainee lawyer at a firm here. I participated in a 2023 summer program online, and I enjoyed it so much that I'll be joining you in Porto, this time in person. And so, as Carolina said, together with the team, we're preparing not only a very rich academic program, but a really strong social and cultural experience, so you can enjoy Porto to the fullest. You won't hear me saying this in Lisbon, but secretly, Porto is my favorite city in Portugal. And if you come, you'll know why. These pictures show you a glimpse of what we're gonna have. You'll have, your evenings packed with city tours, site visits, wine tastings, because of course we're in Porto. We'll probably taste a little bit of francesinha as well. And if this sounds interesting, you can scan the QR code that will be showing in the next slide. And you can register via the ICFML website and take advantage of our early bird that will be going on until May, the 22nd of May. And so just bring your sunscreen, come enjoy summer in Porto with us. If you're still deciding, don't worry, we'll be sharing some more information in our socials, so you can check out on LinkedIn or Instagram and see, a bit of a sneak peek of what we'll have in this year's edition. Pass on the floor again to Carolina.
I would like to thank you again to Franco and Nicolas, and we hope to see all of you in Porto soon. Thank you.
Thank you. Thank you, everyone.
Thank you.
Thank you.
Thank you. Bye.
Bye.
Thank you.